In reply, the Honourable Leanne Dalziel.
Mr. Speaker, I'm very disappointed that the National Party has adopted a position in opposition to a bill because they have been advised by their research unit notes that the problem is all fixed. Because the problem is not all fixed, and it was very interesting that every single member of the National Party who spoke, with perhaps the exception of Jonathan Young, who had sat on the select committee that heard all of the evidence that was presented in relation to the finance company failures, which heard from people who'd lost money in the ANZ-ING debacle, which should never have been allowed to occur in this country. And people will reflect, I think, for a long time on the behaviour of a number of the people involved. But let me just say that he at least understood what it was that the bill was designed to do, because he wasn't sticking to prepared notes. The truth is that the government members have been told that the legislation is no longer necessary because it is fixed with the new requirements that say that a provision of an agreement or a deed is void if it provides that a party to the agreement or deed is required or bound to waive compliance with any requirement of this Act or the regulations. That's not what people were required to do. And in fact, the way that the group that was established at the time, the way that they described it was that they said the offer's condition was that customers will surrender their right of legal recourse against ING New Zealand, ANZ or their financial advisors. Customers also lose their right to benefit if the Commerce Commission finds ANZ-ING breach fair trade. The Frozen Funds Group has called this a form of blackmail. And actually it was, because there was nothing else. They had to either accept the offer or the offer came off the table. It expired at midnight on a particular day, and that was the end of the offer. So they had no choice but to accept the offer, and the condition was that if you have breached the rules that apply under fair trading with the Commerce Commission, if the banking ombudsman were to make a ruling that were generally applicable, then you would get no benefit from it. You had to rescind that right. And the problem that I have with that is simply this. And there is no problem with making the settlement conditional on not proceeding with a civil course of action. I've got no problems with that, and in fact that was an issue that came up as well. That occurs every day. We give up something in order to get something, and in fact the settlement with the Commerce Commission was so they didn't take them to court for their blatant breach of the Fair Trading Act. But where a regulator has identified that there has been a breach of the rules that were designed themselves to protect investors, then no agreement that in any way undermines the authority of that regulator should be allowed to stand. It should be illegal. And that's why I chose that particular model of the change to the Illegal Contracts Act. Now, I know that the Financial Markets Conduct Bill is in front of the Select Committee at the moment. There was no harm in sending this bill to that select committee so that they could make sure that they get that clause of the legislation into shape where it would actually protect people from being blackmailed in this way in the future. And I think that that would have been a reasonable outcome instead of having a predetermined position come to the House and actually argue a point of view that wasn't substantiated by the legislation that they were referring to. I think it is a disappointment because this was a chance for the government to set aside, perhaps the politics of the situation. And in fact, when I was the chair of the Select Committee, I can say without a shadow of reflection that we worked really well together on both sides of the House, in fact with the Greens and as well, in order to achieve some good outcomes in relation to the financial regulation that we started and which National continued on. And I believe that this was an example of a bill where the government has simply just misunderstood that there is a gap in the legislation that needs to be filled. This was a bill that could have filled that gap, and I make a last-minute plea to the government. Please support it to Select Committee. At least we can resolve the differences there.
The debate has now concluded. So the question is that the motion be agreed to. Those of that opinion will say aye. Aye. Contrary, no. Noes have it. Party vote. Clerk will conduct a party vote.
New Zealand National.
59 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party.
14 in favour.
New Zealand First. Maori Party.
3 votes in favour.
Mana.
1 vote in favour.
Act New Zealand.
1 vote opposed.
United Future.
1 vote opposed.
The ayes are 60, the noes are 61. The motion is not agreed to. Call on members' order of the day number 4.
Parental leave and